A very warm welcome to you, ma'am.
And to you. Nice to see you, Sumi. Thank you for inviting me.
Nice to see you, ma'am. Greetings. Hello and welcome to Me-Arcone Queing, a platform dedicated to meaningful conversations on alternative dispute resolution and its growing relevance in today's legal and social landscape. I'm delighted to have you with us for today's episode, ma'am. At Me-Arcone Queing, we strongly believe in promoting peaceful, efficient,
I'm
collaborative.
delighted to be here. Thank you for the invitation.
Yes, ma'am. Collaborative method of resolving disputes. With the aim of reducing excessive reliance on litigation. While the judiciary plays a crucial role in delivering justice, courts across the world remain overburdened with cases, many of which involve minor disputes, interpersonal conflicts, or matter that could be resolved more effectively outside the courtroom. Alternative dispute resolution mechanisms such as mediation, arbitration, conciliation, negotiation offers a constructive way forward. ADR not only help in saving time and costs, but also preserves relationships, encourages dialogues, and empower parties to participate actively in and maintain control over the resolution of dispute resolution. By resolving appropriate matters outside the courtroom, ADR allows the judiciary to focus its attention on complex and serious cases that truly requires adjudication. Through this platform, we aim to create awareness, spark dialogues, and strengthen trust in ADR as a first choice mechanism for justice delivery. At Me-Arcone Queing, we have wholeheartedly embraced the transformative potential of alternative dispute resolution and brought it to life through this dedicated podcast. This platform goes beyond delivering insights. It serves as a dynamic bridge connecting ADR professionals, practitioners, students, and enthusiasts across India and beyond. Our object is to foster greater awareness, deeper understanding, and stronger preference for ADR as a trusted and effective mechanism and method of resolving disputes. Driven by our mission to position ADR as a first and foremost choice for conflict resolution, each episode features thought-provoking discussion, expert perspective, and real-world success stories. Through these conversations, we highlight how ADR resolves disputes swiftly, amicably, and win lasting impact while strengthening to the justice. Now, a small introduction from my side. Before we begin, a brief introduction from my side. My name is Sumi Roy. I'm a final year law student at Asian Law College, Noida, and I'm currently an intern at Institute for Alternative Dispute Resolution. It's a pleasure to be your host for today's episode, ma'am.
Oh, it's a pleasure to see you, Sumi. I really appreciate the opportunity to speak to your audience and to learn more about you through your introduction. That's wonderful.
Thank you, ma'am. Now introducing our esteemed speaker. Today we are honored to welcome a distinguished voice in the world of dispute resolution, Ms. Felicia Harris Hoss. Ms. Felicia Harris Hoss is a nationally recognized commercial mediator and arbitrator with nearly 3 decades of experience helping parties resolving complex business and civil disputes before they become costly legal battle. A former trial partner at leading regional and national law firm in Texas, she now serves full-time as an independent neutral, bringing deep litigation insights to early and effective resolution. Ms. Harris is a credentialed distinguished mediator, a member of National Academy of Distinguished Neutrals, and has been consistently recognized among the best lawyers in America and as a Texas super lawyer in alternative dispute resolution. Over the years, she had mediated more than 400 disputes across industries including energy, healthcare, construction, financial services, property rights and interest, employment, insurance, and complex commercial matters. Beyond her practice, Ms. Harris is a thought leader and advocate for alternative dispute resolution. She is a co-author of the ABA's Resolution 500, which encourages lawyers and clients to meaningfully consider early mediation and a structured evaluation as a standard practice, signaling a powerful shift in how disputes are handled in United States. Ms. Harris regularly speaks at national and international forums, contributes to leading legal publications, and works closely with bar associations and institutions to reshape how lawyers, businesses, and courts think about conflict, not as something as escalate, but as something to resolve intelligently, early, and humanly. Today's conversation will explore why early mediation matters and how EDR decision making and what the future of dispute resolution looks like when clarity replaces momentum and strategy replaces fear. Please join me in welcoming Ms. Felicia Harris Hoss. With your permission, Ms. Harris, may we begin today's conversation?
Absolutely, I look forward to it.
Thank you, ma'am. With your permission, Ms. Harris, may begin today's conversation. Ma'am, there is a question segment, so should I ask question?
Yes, go ahead. Ask me the question. I'll be happy to answer them.
Thank you, ma'am. Ma'am, my first question is, how do you define early dispute resolution in practice? And at what stage should mediation ideally step in to avoid a dispute from turning adversarial?
Oh, it's a great question and great leadoff question, Sumi. It's a pleasure to be able to introduce the idea of early dispute resolution to your peers and to others who are listening to the podcast. It's really a voluntary strategic process, right? To help parties avoid and resolve conflicts before they escalate into litigation or into arbitration or shortly thereafter, right? Before they spend years at the courthouse for a trial that likely will never happen. So the process itself is designed to help parties make informed decisions about whether to pursue a resolution early or whether it's not possible and they must go into litigation or seek the assistance of a third party, like a judge or an arbitrator, right? The one thing to highlight about early dispute resolution that a lot of people don't necessarily appreciate is that over here in the United States, less than 1% of all cases that are filed at the courthouse actually go to trial. So, and most arbitrations are resolved before the final hearing as well. So most disputes, the majority of disputes, 99% of them are going to get resolved before the trial of the arbitration. So it makes sense to strategically think about whether you can resolve the conflict or avoid the conflict early. And this process that we talk about is a process that effectively does that. And it's different from the concept of a mediation just as a day in the life cycle of a conflict, right? There's actually a structure behind the early dispute resolution mediation process. And if I might briefly just describe it so your listeners can get a sense of how it may be different. I guess, first of all, the thing is you engage a mediator, right? And the mediator is not someone that simply shows up on the day of the mediation and says to the parties, what is going on and how can I help you? This is a process in which the mediator engages over a period of to help the parties identify what is the conflict about, like what are the key factual and the key legal issues that are really going to drive business folks who are going to be asked to make the decisions about resolution or going to trial. And then once you've identified those key legal issues, those key factual issues, you're in a position now to work with the mediator to decide what kind of information is needed, not the stuff you want to try the case, but what is needed to make sufficient, to have sufficient information to make key decisions and to work with each other, the parties and the mediator, to exchange that information before you actually start a negotiation process. And then one more step before you start the negotiation process, and this is critical because this doesn't happen in most early mediations unless you go through a process like this, and that is to analyze the risk and evaluate your options for resolution, financial investments and the non-financial investments. but things like market presence, branding, consumer feedback, regulatory exposure, the interactions between you and your vendors or you and your suppliers, your counterparts, etc. And then once you've decided that, and you may even do a decision tree to help you see at which decision point and how each decision point may affect the ultimate outcome if you don't get the case resolved early. And then you can negotiate. You negotiate with information, with data, with facts, with objective viewpoint about what the dispute is about, and an understanding from both sides or all sides if it's a multi-party conflict, what is driving the dispute. And then if you need to, I mean, and all of this is taking place remotely, right? So you don't have lawyers and their clients sitting in a room, the times with each of the parties over a series of days or weeks. And then ultimately the negotiation can begin through this virtual process, saving the parties a lot of time and money. And what this does is it sets the stage for negotiation. And if in that remote negotiation, a resolution is not achieved, certainly the mediation session can be scheduled at which the parties can then engage and set aside a day to negotiate to final resolution if possible. And if a resolution isn't possible, because sometimes it isn't, they may negotiate something else, right? And that is the bespoke process to get the case resolved later. I know you want to hear more about that, so I'll just lay the groundwork for that insight later.
Right, ma'am. Right, ma'am. Thank you so much, ma'am, for such an informative answer.
So, you're welcome.
Yes, ma'am. So, ma'am, second question is...
Here's the next question. Do you want me to...
Yes, ma'am. Yes, ma'am. Many people fear that opting for early mediation signals weakness. So how does EDR actually strengthen a party's strategic position rather than dilute it?
You know, and this is probably a question that I love the most of all the ones that I get to answer when talking with people about early dispute resolution. So I'm so happy and delighted you asked it.
Thank you, ma'am.
Early dispute resolution, early mediation, who do think that the suggestion of going to mediation before you've spent years at the courthouse or years in arbitration is a sign of weakness. And I'm here to say that I believe that is a complete fallacy. In fact, if done the right way, early mediation can be a part of your standard operating procedure. And in fact, in many business contracts, early mediation is already baked in. It's already a key component. There are many contractual provisions which require a mediated process before you go to the courthouse or before you go to arbitration. So how do you do it effectively is really the better question, right? We've been doing it for years, but how do you do it effectively? How do you make it meaningful? And so I suggest this. It should be a part of an overall risk management dispute resolution strategy. Make it part of your standard operating procedure, whether or not it's an internal or external relationship. And in those instances in which you don't have contracts, let's say there's a negligence claim or some sort of duty claim that doesn't arise out of a contract where you might have an early mediation provision, have your lawyers approach each other and say, you know, we all know the likelihood of going to trial is less than 1%. Doesn't it make sense for our clients to at least gain a better understanding about what they're going to be fighting about before they decide to spend a lot of money in that system in which they lose some certainty and so much stress, and the greater impact on the business could be in the market, right? So why don't we at least engage a mediator, try to help our clients better understand what it is they're going to be fighting over and why the fight is necessary if it is, and then position them to make those key decisions. So essentially, you know, for outside counsel, an early mediation process does really, I think, three things. It helps them manage their risk and leverage their relationship with their client before the discovery process and before expenses get escalated. It helps them with the client better understand the conflict, and it sharpens everyone's expectation, right? What are going to be, who are the key witnesses? What are likely to be the key documents? Likely to be the traps or the pitfalls in our case, and how do we address them? And then thirdly, it helps them in the case on the courthouse steps. We're really thinking about, can we resolve this case? And for inside counsel, this process helps position strategic problem solvers to the business clients they serve. And early wins for an in-house lawyer, we know, helps that relationship bolster trust and confidence in decision-making. And it allows the in-house lawyer to position himself or herself as a bigger picture strategic thought leader and focused on the business's core mission, right? And then thirdly,
Right.
general counsels, those leaders of the in-house
Yes, ma'am. Right.
teams, it helps reduce the legal spend, right? If you're able to gain greater control over the process and make strategic decisions about whether you go to the courthouse, you can then manage your legal spend better and your legal budgets better. It provides more predictability in the way that they address dispute resolution and provides a leadership opportunity, if you will. And key, an early mediation process allows the legal teams and the business teams to work collaboratively to be less, to let the conflict be less disruptive to the business operations, and lets everyone keep their focus on the prize, right? The bigger picture. What is our core mission? What is our key market strategy? Let's don't let this conflict or this dispute interrupt or interfere with that.
Right, ma'am. Well said, ma'am.
Thank you.
Thank you so much, ma'am, for such an informative answer. Third question. You often describe EDR as a bespoke alternative to the default litigation path. What does a bespoke process look like compared with a standard court timetable?
Very good question too, because as I mentioned earlier, not every case that goes through an early mediation process is going to resolve fully. But there are those that more information is needed, or perhaps wrong decision, the decision maker really receive the they need, the board of directors or whatever. So what this does is this allows the parties at the end of the session, early mediation session, to talk not about just going to the courthouse and going into the discovery process and taking all their depositions and setting up their motions for summary judgment and fighting over motions to compel. This allows them to say, look, we now know so much more about the conflict. I think if we knew X, Y, and Z, or had a better appreciation about A, B, and C, or maybe if we deposed or interviewed, this witness or that witness, or maybe it's the damages model. Maybe we need to engage our damages experts, get a better handle on what the numbers look like, exchange a little more information, highlight those key decision pieces of information, and work on getting those exchanged. If it's a deposition, get those depositions on the schedule and taken to an arbitration and keep it out of the public sector. You can have those conversations too, and then put that into an agreement, put that into writing, have the parties design their own process as opposed to the fallback of the rules of civil procedure and the rules of evidence and all that goes into that, and set their own deadlines for the exchange of information and hold each other to that. So once you're able to do that, then that sets up what cost savings and time savings, right? And I'll share with early cases who want help, right? We are at this stage and we still have some work to do, and we would like your help to get us across this finish line so then we can set this up for the next mediation session or the next mediation process. Control allows them to make those decisions about how they want to resolve their conflict.
Yes, ma'am. Well said, ma'am. Thank you so much, ma'am, for such an informative answer. And my third question is, an employment and workplace dispute, where do you see early mediation provide the most value for executive, for employees, and for wider culture of the organization?
Yeah, the employment disputes are just perfect for early mediation, right? Yes. Because either they involve oftentimes claims of harassment or discrimination, or the enforcement or non-enforcement of a restrictive covenant, typically dealing with non-solicitation or covenants not to compete or secrets, confidential information. So a lot of those disputes, I've handled them as an advocate and I've mediated them as a mediator. They involve oftentimes miscommunications, misunderstandings, some mistakes may have been made, some feelings may have been hurt because of misinterpretation of something. And so an early mediation allows management, right, to send a message to its workforce that they're listening, that they want to do the right thing, that they recognize we're all human and we sometimes do make mistakes, but those mistakes are not intentional and they're not intended to undermine their interest in promoting a strong and talented and loyal workforce, right? So for the management side, it shows we're listening, we're hearing, we want to work with you. For example, if an executive is caught up in an allegation of harassment or something like that, and they're willing to sit down with counsel or without counsel and have an early mediation on the issue, it shows they're a good leader, right? It says sometimes we need a 360 review, and if I've made a mistake,
Yes.
I'm here to reconcile it. And if I haven't, let's clear the air on that too, because if your feelings have been hurt, then I need to know that, right? And for everyone, the employees who are not involved in the mistake in that conflict, it shows to them that the company is a leader, it is thoughtful, it is a company that cares about its workforce and a company that is interested in doing the right thing. And let's just face it, if it's a trade secret case, I mean, it behooves everyone to talk privately in a confidential setting
Yes.
about what it is that the trade secrets are and whether they've been taken or whatever, right? So this process is one of confidentiality as well. It's in our state in Texas. And I just want to highlight this to me because the idea of employee-employer disputes, this is really, I get this question a lot, right? But another aspect of the employment arena is when you have closely held corporations and the owners may get into a dispute. And it could be a company that has, many employees or not so many employees, but when the owners are in conflict, that signals to the rest of the workforce instability. That signals to the rest of the workforce, our leaders are not on the same page. And so where is this company going? And so and investors, investors are watching. Do you have some prospective investors who might get skipped about, again, it allows them to have a meaningful conversation, exchange of information, working with a mediator to resolve the conflict privately and confidentially so that they can then get on with business and get on with the things that make the company money versus those things that actually cost the company money. So I hope that answers your question.
Right, ma'am. Well said, ma'am. Like the early mediation is best for workplace, like harassment, discrimination. Well said, ma'am. Thank you so much, ma'am, for such a
Yes.
informative answer. And my last question is, beyond legal fee and verdicts, what are the hidden costs of not opting for early mediation? Costs that businesses usually recognize only much later when the dispute is already behind them.
Right. So when let's take the hypothetical, right? Your company has been sued and you have gone through the discovery process, you've gotten to the courthouse, and let's say you went through a little long trial. Let's say it's a day trial, maybe it's a month, whatever. At the end of the day, there's going to be an outcome. And whatever that outcome is, it's going to be a public outcome, right? And so
Right, ma'am.
when you're able to resolve the case confidentially and before you've invested those years of time, you're able to protect your brand, you're able to protect your reputation. And those are costs that a lot of people don't factor into it, the early decisions, but they should. The other piece of that is that, we now live in a world where once cases are filed, there are oftentimes headlines made. X company is getting sued for X, Y, and Z, or A, B, and C. And so those reputational costs factor into
Right,
it.
ma'am. Right.
You have diversion of resources. For example, employees who are going to have to now spend time gathering documents. And the cost of holding on to those documents is exorbitant nowadays because you're going to have to preserve the evidence, right? So all of those costs have to be factored in addition to the costs of experts and the costs of travel and the costs away from your core business You have employees who are showing up for depositions and spending 3 or 4 days preparing for those depositions instead of doing their work. And they're stressed. And the stress on your employees, and the insightful your question is when you think about all those hidden costs that are imposed upon business owners. And if you're a small business, it could wipe you out because the cost is so exorbitant, you may just not be able to carry the load. For big businesses, they set aside reserves, and it may be one business unit or another business unit that pays the cost. But nevertheless, cost that even GCs keep their fingers on, and this is why early mediation is a way for them to sort of put all that in the mix. And that, remember those stages I talked about in that information exchange stage, the internal information exchange, and in the analysis stage where they're looking at that decision tree and they're deciding how much is it really going to cost. Don't just look at the monetary costs, look at the soft costs too, and factor that in and have that be part of the analysis for what are reasonable settlement ranges. I hope that answers your question.
Right, ma'am. Well said, ma'am. Thank you so much, ma'am, for such a valuable answer.
You're welcome.
Now, before we conclude, Ms. Harris, we would love to hear one piece of advice from you, ma'am, that could encourage and guide young lawyers who are just beginning their journey in the legal profession.
And my piece of advice is this: always, always, always go the extra mile for the client, right? If it's always put yourself in the client's shoes and try to understand their position, whether it's as a witness or as a key decision maker. They have their own internal stresses, and the legal system is not something that they like being a part of. So help them better understand their options, make decisions, and get out of it as quickly as possible.
Yes, ma'am. Right, ma'am. Ms. Harris, thank you so much for joining us today and for such a thoughtful, insightful conversation. What really stand out is not just your experience or the number of disputes you have helped resolve, but the mindset you bring to the conflict, the idea that dispute don't have to become battle, and that clarity, timing, and conversation can change outcome of the powerful ways. Your work in early mediation and early dispute resolution reminds us that waiting is often the most expensive decision parties make. Emotionally, financially, and strategically, the way you have explained EDR today, it makes clear that it's not about avoiding accountability, but also choosing a smarter, more human path forward. We're truly grateful for your time, your wisdom, and the work you continue to do in shaping the future of dispute resolution and continue to inspire professionals and students alike. Thank you once again. Thank you, Ms. Harris. It's been an absolute pleasure with you. Pleasure having you with us today.
Sumi, thank you.
Thank you, ma'am. To our listeners, thank you for tuning to the Me-Arcone Queing. We hope today's discussion encourages you to reflect the power of dialogue, collaboration, and alternative pathways to justice. Until next time, stay engaged, stay informed, and continue believing in peaceful dispute resolution. Thank you so much, ma'am, for your valuable time.